It is possible to renounce or disclaim a will or the benefits of a will. There are certain restrictions and rules that have to be followed in order to do that, but it is possible. For example, suppose that I have creditors, and any inheritance I receive from my father will end up being taken by my creditors to pay my debts. If, for example, my father's will leaves $100,000 to me, but if I predecease my father, then that $100,000 share will go to my two children. Again, if I have a lot of creditors out there that will end up taking that $100,000 from me, I could disclaim that $100,000 that I'm supposed to inherit, and in my example, that disclaimed property will pass on to my children because that's what my father's will specified would happen. Before you make a disclaimer, for that reason, you want to be sure that you know what the consequence of the disclaimer is. If, for example, the will says if Mark predeceases me, I want his share to go to charity, or I want his share to go to my brother who I hate, then I may not want to make the disclaimer because the property will go someplace that I don't want it to. Bear in mind that I cannot disclaim and direct where the property goes. My father, who I was to inherit from, is the one that directs where the property goes. So if you make a disclaimer, you cannot control where the property goes. There are other reasons besides creditors. Sometimes people disclaim because by receiving that inheritance, I may be subject to greater death tax myself. So for example, if I know when I die I'm going to have a large estate and I'm going to pay taxes when I die, I may want to disclaim that $100,000 that comes to me because that my estate will just be subject to greater tax because of that inheritance. You have to be aware of deadlines, and again, you should be careful to make sure you know who that property will pass to before you make the disclaimer. So it's important to investigate the consequences of your disclaimer.